Hi, I'm Sam Hayes, One Stop Transaction Services. I wanted to talk to you today about the new forms that are coming out next week, June 27th from CAR. I have been doing this for over 20 years, working as a transaction coordinator. I am a licensed realtor, certified transaction coordinator, certified forms trainer, and basically I just really love this stuff and nerd out on it. So I love to talk about it whenever I get a chance. I want to make sure I remind you of three things before we start. The law was changed in January of 2023 regarding the fact that you can use any previous disclosures that you've had on file that are of that type. You don't have to use the most current version. However, CAR forms coverage and also your E&O may not agree with that. So make sure you're double checking everything with the broker of record on the file you're working on, as well as your E&O moving forward. With that out of the way, let's jump right into listing agreements and the changes that are coming next week. One of the biggest issues is the fact that you now can go ahead and presentation of offers can be held until received or a specific date. So what does that mean? If you have a client that is traveling or would like to wait till they get multiple offers, say you have a couple of open houses scheduled, you can go ahead and set that up in your listing agreement. Well, this has been a common business practice for many throughout time here in California. It is now actually technically in your listing agreement and can be agreed to prior to looking at the offers and setting up any time frames while you're waiting to go into escrow. The other big addition has been the fact that there are now signature blocks are added back in. So you have your signature with emails, addresses, phone numbers. For those of us that are transaction coordinators, escrow lenders, a lot of that information that's where we get it. So without having that there, it was having to pull it out of agents, which has been a little challenging. So I'm very happy to see that's returned. It's also discussing the fact of smart home features are part of the transaction and what's going to transfer, what's not going to transfer. And then also the fact of with your vacant land that the seller broker are responsible for their own attorney's fees unless the party does not attempt to mediate. There is a new form coming out, the ROPD and the ROPQ, which we'll get into further, that's more impactful if you were doing property management. Regarding cancellation of listings, this has been changed that any number of paragraphs may be checked, but both options within paragraph 1 may apply. So that's saying that you can go ahead and have several different reasons for why the cancellation is happening, but you only have to have one of those paragraphs checked. The other issue is it does clarify now any amount of money that will be owed to you as a listing broker if that property is relisted with another brokerage. Things are on the market a little bit longer right now. Things are taking a little bit more time. There may be a disconnect with your client. Make sure you are also reviewing and talking to your brokerage about page 1 of the RLA itself for how many days after a listing expires or is canceled that there is the liability or the owed commission liability of the seller of owed commission back to the brokerage once you have given the list of all the individuals or brokerages you've shown the property to. Contracts really haven't changed as much. There's a couple that were major ones that will stand out a little bit more so for you. A lot of it is for the newer construction, identifying that the SB 80 statutory warranties always apply. And with the RIPA, that's Rental Income Property Purchase Agreement, you're going to have that TOPA. So what is the TOPA? That's a tenant occupied purchase addendum. If you have an individual in the property for 1 minute after you go under escrow who is over 18 and not on title, you have a tenant. I currently share a house with my mom and I am considered a tenant. I would need to be listed as that, even though I know as a family we would need to vacate the property. This TOPA is required with revision of the contract as of January of 2022, January 2023. What that states in the contract is if the buyer's agent is aware of tenants, they are to include the TOPA. If they're not, say they think I was just family or not know if I was on title, then the listing side needs to include that document. Now, the TOPA can go through and reiterate if somebody's remaining in the property, and if they are, then it would clarify if you say we're going to include estoppels, leases, all of those type of things. But it also clarifies that if for some reason the seller is to deliver the property vacant and they are unable to do so, that they are to reimburse the buyer for inspections, appraisals, and reasonable costs. Well, I'm not sure what reasonable costs are. You may not be either. So that's something you're going to want to definitely document, clarify, and make sure your clients are aware of if there's any challenges or concerns that a tenant may not vacate the property in time for close of escrow. Little side note to be aware of. The other issues that coming through is, again, with the leases changing those terms, is going back to that rental owner disclosure. For basically, that's kind of helping for the individuals, the property owners, to let their property managers know these are the different facts to know about the property. These are different little bits and pieces. We'll get into that more as we go through the slides. Now, with your counter offers, a big thing that's been an issue before is the appraisal gap. So before, if he didn't clarify that in the counter offer, that stayed the same as what it was in the offer. Now it is actually being addressed and clarified again if your price changes in your counters. You're going to want to check out RPA 3L2 for this section of the document. The only other new forms to really be aware of is that the contingency removal has been split into two sections. It is now contingency removal for the buyer and contingency removal for the seller. As we know, contingency removal for the seller, there's really only two times you can do that. That's when the seller has a replacement property, or that's when they have to identify the replacement property and then close on it, unless you write in a specific contingency, which then you're going to want to double check with your legal team and your broker just to make sure for the verbiage. Now, on the buyer side, this new contingency removal form actually adds clarification about that when they're removing their investigation contingency, they also can call out, did they investigate the floods, fires, or other insurance issues? These are some things that are a little bit more clarified where there's specific boxes and it's getting more and more detailed. When you are removing that investigation contingency, you're going to want to make sure that your buyer has secured insurance on the new property. As we know, with all the changes in the fire and the home hardening with CAL FIRE and the Department of Insurance interacting right now, we're going to need to make sure that your client can afford the insurance coverage required in addition to their mortgage payment. Unfortunately, I've had some transactions recently and talking to some mortgage brokers at some of my presentations. They're taking everybody right up to the edge on their debt ratios that a $200, $300, $500 a month insurance payment can blow the entire deal. So you want to probably have your client talk to their insurance provider prior to taking them out. If they're looking at something in a rural area or a potential high fire zone, mention to the insurance provider, hey, I might be looking at a property in this zip code. Could you ballpark me? And it's something that way the issue of the cost of that insurance is put onto that third party who can answer the questions, and it helps your client make a better choice instead of you having to say, hey, we now have to look at $100,000 cheaper homes or $200,000 cheaper homes because you can't afford all the payments. Part of the due diligence of doing your homework before you take somebody out in the car. Cancellation of contract. This is also now added language explaining how to fill out if only one party is canceling, or is it mutual? Did everybody decide this isn't working? We want out. Never mind. We found something that's a problem. There is also a language addressing a partial release if no deposit was made. So I know I've seen this as a business tactic and something that we've done for years, where a partial release of deposit has been set up for making an offer look better, getting some cash into the seller's pocket ahead of time. Here's the problem, and this was addressed with the two revisions of the contract, both when we did the 2021 and the 2022 revisions, is the fact of what happens if, for some reason, the buyer's supposed to get that deposit back and the seller's already spent it. What do you do if they were supposed to partially release, but no deposit was ever given? How do you enforce that? And that's actually civil code. There's specific verbiage and language that's to be used for that. So you're going to want to double check RPA 8 and then run it past your legal team and your brokerage. Make sure you're getting it correct. Because remember, every time you add any language or any verbiage to the contract, you are now changing the terms of the contract, one, but two, you're also practicing law. And last time I checked, most agents, I know there's some out there, but most agents are not lawyers. So let's mitigate that liability and have it checked through and protect you and your client, as well as manage their expectations and do your fiduciary duty. Now, this is not in play right now. As we know, there has been a stay and a delay because of the 8th Circuit Court reviewing everything that is happening with NAR and the DOJ lawsuits. But if you come into a situation that you need a buyer representation broker compensation. This is basically all it's done is just add the signature back like we were talking about with the listing. So we have the contact info. That's it. No big deal. This is not a form we're dealing with right now. However, there is the potential that later this year, we're waiting to hear in the fall if this is going to change and do all those impacts. Right now, this is kind of just a basic, little quick update. And as we know, if you do need that, then you would do 3G for doing the seller payment of buyer broker. You've got to have the BRBC to prove that you already had the agreement before you write the contract. And this is just the clarification of that in the form stating, hey, you got to have this buyer broker agreement before we can ask the seller to pay for it, because we got to prove that you already made this agreement. Simple. Again, we're not dealing with it yet. Nothing to worry about at the moment. The representative capacity signature disclosure, this has now been changed up so that it's just one signature. So you have one if you're a buyer, one for the buyer broker, or excuse me, for the buyer, one for if you're doing it as a seller, and one as a tenant. That's it. It's not going to be all the different signatures boxes where, oh, you signed it because we're not doing it to this, or it's not to the listing, or it's not to the AOAA. It's all that's being removed. It's just one form, simplified, cleaned up, much easier. Getting into our acknowledgements, addendums, and advisories, there's been a little bit of small changes, but things that do impact the reasoning, and it helps understand why these forms exist. Every time a paragraph is added, there's been some sort of litigation or calls into car legal, and that's why they come about. So if you do the additional broker acknowledgement, this is just going to clarify all the agents as well as the brokerages. Similar to, it's kind of combining and adding an AAA, so we know everybody's names who are allowed to be part of this. The BHAA, that's just stating, hey, HOA litigation, that may impact whether or not a lender is going to lend. Kind of important. On your disclosure information advisory, this clarifies that, yes, you do need to provide any information that you already have on file. If you have previous disclosures, previous inspections, that typically includes the brokerage too. If you had been representing them as a buyer, now as a seller, you're going to want to check with your broker and legal team for what is best practice. But typically, more information than less is always the best choice to do. Notice of perform has been added to clarify. Say you gave it early and the HOA docs, they've only had for 3 days. Well, instead of nulling out the entire notice to perform, it just says that, look, only these are the ones that are valid are valid. If it's not valid, then fine. We'll send you a new one when the time frames. So it takes away that whole delay, which I've had happen several times. If you didn't have it exactly perfect, this gives a little bit more breathing room. It's also making it probably going to be a form used even more than it already has been. On the assignment of agreement addendum, now this is RPA 23, that if you are doing anything regarding the transaction, if you're assigning it in any way, shape, or form, putting it in the trust, adding a buyer, taking off a buyer, adding mom, adding dad, whatever you're doing, this clarifies, is the original buyer going away and now somebody else because they have better credit? Are we changing to the LLC? It's just a little bit more clarification to understand how to use the form. And no matter what escrow tells you, you need that form. It's in the contract. Cash for keys lets them seek legal counsel. It's not just payment, but also for the tenant has to give up the space to get the cash for keys. Your mobile home purchase addendum is clarifying that either buyer or seller can cancel if the buyer does not get approved by the park. That could be due to 55 and up. That could be due to HOA requirements in that park, all sorts of things. So it doesn't work. Seller can say, fine, I'm moving on to the next person. And then for your purchase agreement to the probate addendum, this is going to clarify that if you don't have confirmation within 60 days, buyer can cancel. They don't have to hang around. They're not stuck. They're not tied into things. If we can't get a decision, they get to move on. Additional updates were to the SBSA. This now will be a 15-page form. It includes that you need to actually read those prelims, including the CC&Rs. There could be impacts due to the laws eliminating the use of carbon fuel appliances. I know that's still up in the air. It also says that the discriminatory covenants can be removed from title, that they have the option to do that. And solar power system owners' fees and credits may be reduced or not changed. So it may not transfer what this seller has to what the buyer is going to get from that solar company. So the new form that came out is that we've been talking about is this rental property owner questionnaire. And this is like all the questions and whatnot. And this is going to go between the broker and the property owner. And it's to say all the different things so you know what you're representing and what you're trying to rent out. Where the property owner disclosure is specifically created to be handed over to the tenant as well as the brokerage. So there is a slight difference there of information and what's being released and how it's going to be handed over. The rental units purchase addendum. So this is similar to the MUPA that came out, I think it was about a year and a half ago. So basically this one's if you have a lot of commercial, but a little residential, you'd use this form. Where the other form for mixed use is a lot of residential, little bit of commercial. Basically, it's going to depend on how much you're using, which contract you're writing on, and then you'll know which one of these two forms to use. It helps meet all the disclosure requirements and get a little bit more into detail that sometimes when you've got something that doesn't quite fit in the box, how do I handle this? Well, both forms were created to meet these needs. The solar disclosure has been updated that it's a catch-all for if there's any material fact whatsoever, go ahead. This is the place to do it regarding solar specifically. Now, 13M and N address solar and material facts. Currently, the solar disclosure is not a requirement. It is encouraged to be used, similar to the way the action of the AVID, where the action and civil code requirement of an agent inspecting the property is required. However, the use of that form is not required. Same thing's happening here. But remember, the sooner you can get this information and the sooner you can find out about taking over leases, are there any other companies servicing that maybe there's some back fees? I've had that show up on title and it's delayed close of escrow. Making sure that they actually own the solar, that's been an issue before. This is the time you definitely want to start asking about this when you take your listings. The TDS and SPQ are both also being changed where they can be utilized, where you should do a SPQ, TDS, AVID for every single unit. So if you have 1 to 4, you should do, TDS for unit 1, TDS for unit 2. Granted, that is up to the broker of record and how you want to handle your file, risk management, all those things. This is changing the format of these disclosures so that they are more user friendly. And you can say, I've got multiple units. My understanding from my training with CAR last week was that both Glide and CAR zip forms will have that set up so you can have the multiple ones in both their systems. The SPRP. So a lot of times we have those two contingencies. We have identifying the replacement property and then closing on the replacement property. And we go under escrow and they've already identified that replacement property, but that contingency has not been removed in writing. This clarifies if it's already identified, if you can tell me what the address is, because you've included this, that contingency doesn't exist. You've identified the property. So it kind of gave a wiggle before that has been an issue. This is saying, no, that's not happening moving forward. It also goes through and it better outlines the rights of each party for their cancellation. The TOPA, as we've discussed, obligates the seller to identify the names of all adult occupants. That's occupant, not owner, occupant. And that's for 1 minute. If you were in escrow, even if they're moving out tomorrow, you want this form on there every time. And even if they're not paying rent, doesn't matter. Animal terms and conditions addendum. This was updated to kind of take over the PET, and you can be used for service animals or it can be used for just pets that are there for humans to enjoy. The thing is, it also clarifies which rules will apply if it is truly a service animal or if it is a family pet. Leases. We no longer use the word landlord. Landlord is gone. We now use the word housing provider. All of these forms were changed just for that specific reason. And to meet all the fair housing requirements, you're going to want to switch to these as soon as possible. If you have something in place already, you're fine. But if not, you're going to, moving forward, make sure you're using the most up-to-date forms. And the lease forms were specifically changed as well regarding the Tenant Protection Act and how to complete if it's not covered specifically by the Tenant Protection Act. Again, more blanket changes to meet the different legal changes, but it's not one of those things where you have to switch them out right this second. If you're going into a new lease, then yes, you should be using the new forms. Again, verify all with the broker of record. I went through this fast. You may have some questions. I am happy to talk about this anytime. I love talking forms. You can reach me at 619-993-7264. My cell phone is more or less surgically attached. Otherwise, please join my Facebook group. I'd love you to be part of the chat's there, and I've been doing more and more updates. So as I see things go wrong, basically I do a quick video, say, hey, this was the problem. Here's how we fixed it. And always, I'm available to be a TC on your next file or for another brokerage, and I'd love to talk to anybody if they'd like a training. Thank you so much for joining me today. I appreciate your time. Again, my name is Sam Hayes. I'm One Stop Transaction Services, and I look forward to talking to you soon. Have a great day.